This is Michael Popok, Legal AF, with breaking news. The Department of Justice is on the attack. Jack Smith's group is trying to break through the assertion of the attorney-client privilege by two more of Donald Trump's attorneys in the investigation the grand jury is doing of the Mar-a-Lago document purloined stolen document scandal. The next two lawyers up on the chopping block, come on down. Evan Corcoran and Christina Bobb, because you're next up at the grand jury. Now, both have already testified, and apparently both at certain times in response to questions by the prosecutor in front of the grand jury have refused to answer on the grounds of attorney-client privilege. And yes, generally, communications between an attorney and a client are privileged under the rules of professional responsibility for the bar of that state or that district, in this case, the District of Columbia, and based on court precedent, legal precedent. But there's an exception, and it's called the crime fraud exception, and it's exactly what it sounds like. So here, because we're talking about a client, Trump, that resides in the District of Columbia, we're talking about DC Bar Rule number 1.6, which basically says the following. Generally, attorney-client communications are privileged, except when a client consults an attorney in order to perpetrate a current or future fraud or crime and relies on the attorney's advice to execute on that plan. Those communications are no longer privileged and can be disclosed freely to people like a sitting grand jury. And interestingly enough, the lawyer doesn't even have to know he's being had. He doesn't even have to know that what is being, let's say, proposed hypothetically by his client about what if into the future, that he doesn't have to even know that he's being used to perpetrate the fraud or crime. That's how broad the exception is. So what do you do when you're in a grand jury like the Department of Justice and lawyers throw up that roadblock? You run in to the chief judge of the DC Circuit Court, who, as part of her powers, presides over the entire grand jury process for all grand juries in the District of Columbia, including the ones 3, 4, or 5 against Donald Trump, related to Mar-a-Lago and otherwise, and you go file a motion, generally under seal, because you're trying to protect the confidentiality of the grand jury process. That's why we don't know actually what happened inside of the grand jury, because that's all supposed to be secret. And so you file a secret motion, and that's okay. And you get before the chief judge of the DC Circuit Court, Beryl Howell, and you have a hearing. And what the burden is on the government, on the Department of Justice, to prove that the crime fraud exception applies. That the client, Donald Trump, in order to perpetrate a crime or fraud, in this case, let's say, obstruction of justice, obstruction of Congress, consulted his lawyer, obtained legal advice, and used that legal advice, baked it in to his actions. Now, the lawyer does not have to be a co-conspirator. The lawyer does not have to be a target of the Department of Justice in order for the crime fraud exception to apply. In fact, generally, lawyers are often duped by their clients and don't know that they're being consulted for that purpose. In some instances, and they are rare, but we have an example with Trump and a lawyer. The lawyer himself is a co-conspirator. So John Eastman, the constitutional scholar by half, hired by Donald Trump to tell him anything he wanted to hear, who devised the whole fake elector, and Mike Pence, put pressure on Mike Pence not to certify the election scheme. He was found back in March and October of 2022 by Judge David O. Carter in the Central District of California to have not only did the crime fraud exception apply, to have documents the Jan 6 committee was trying to get their hands on, that they would be turned over because all the elements of crime fraud exception existed. But the judge also found that the lawyer, Eastman, was also a co-conspirator. It's not an element of the crime fraud exception, but it was an interesting side bet, byproduct of the whole thing, that Trump and Eastman, exactly what the Jan 6 committee concluded, were in bed together as conspirators. Now, there's no evidence that's out in the public that we're aware of that yet makes Evan Corcoran or Christina Bobb yet a target, a co-conspirator. But Evan Corcoran's got a lot of explaining to do after Judge Beryl Howell rules. And based on the odds and all the other times she's ruled in favor of the Department of Justice, those crime fraud exception is going to be applied, and he's going to have to testify and answer all the questions, not just the select ones that he's chosen to do. And Christina Bobb, too. Now, why are they so important in the Mar-a-Lago scandal? It was Evan Corcoran, who took the lead in trying to negotiate the return of a limited set of classified documents back to the National Archive. The National Archive wanted them all and had a pretty good handle of what was missing in terms of volume. And instead of a giant volume like the size of, I don't know, this, if you're watching me on YouTube, Evan Corcoran and Christina Bobb returned this. So not the whole loaf, but barely a slice of bread went back to the National Archive. Department of Justice, getting tips from insiders within Mar-a-Lago and around the president, knew that those representations by Corcoran and Bobb were false. When Christina Bobb signed an affidavit prepared by Corcoran that said everything in this little envelope that I've sealed represents the entire universe of confidential, highly classified documents at Mar-a-Lago, that was false. And the Department of Justice knows it and wants Evan Corcoran to come in and explain why he put Christina Bobb up to sign that. Why did Christina Bobb sign it without doing any kind of due diligence? And this is part of the crime fraud exception that's going to fall. Now, if you think, there's going to be a lot of fighting to do in the courtroom with Beryl Howell, that's true. But almost every time Beryl Howell has sided with the Department of Justice and ruled that the crime fraud exception applies and those lawyers have to testify. Just to give you a rundown of where we are on the scorecard of Trump lawyers that have either had to go in and speak to the Department of Justice on their way to the grand jury or testified in front of the grand jury, here's who we have so far. From the White House counsel, Pat Cipollone, he already testified over the summer. After trying to assert the attorney-client privilege, Beryl Howell ruling against him, he testified in full about everything that he saw in the White House around Jan 6th. He's more of a Jan 6th obstruction insurrectionist witness than Corcoran, who's more of a Mar-a-Lago witness, if you can follow that. Pat Cipollone's deputy general counsel, Pat Philbin, also had his attorney-client and crime fraud exception applied to him, and so he had to testify as well. Greg Jacobs, the vice president's general counsel, he's the one that had the big fight with John Eastman over putting pressure on Mike Pence to not certify the election. He, over initial objection of Donald Trump trying to assert the privilege, was forced to testify at the grand jury by the same judge, Judge Beryl Howell. Alina Habba has got a lot of explaining to do. That's why she's quickly left the scene and is radioactive in Trump world and can't appear in court any longer. Besides the $1 million sanction against her in Florida, she also testified by written oath, sworn testimony, that in the New York civil fraud case brought by the New York Attorney General, when there was a dispute over whether Trump had turned over documents not related to Mar-a-Lago, it was Alina Habba that went to Mar-a-Lago, who knows why, and then represented to the court that she had checked, quote, all desks, all drawers, all filing cabinets, and the personal residence, etc. She literally wrote etc., and she couldn't find a thing. Well, that was done in about a month or two before the execution of the search warrant. I almost said the raid. The execution of the search warrant by the Department of Justice looking for classified documents, meaning Alina Habba either lied, saw all these classified folders, which she's not entitled to review because she doesn't have security clearance, just ignored those, kind of pushed everything aside and said, nope, can't find the documents responsive to the case in New York, so I'm out of here. But she's contaminated. She would have seen and touched these documents. So she's had to go into the Department of Justice, not yet to the grand jury, but I'm sure that's on its way. Alex Cannon, lawyer for Donald Trump, who helped negotiate with the National Archives, he's already given a statement to the Department of Justice and could likely testify before the grand jury. So this is just a short list of lawyers forced to testify by the Department of Justice successfully over the attempted assertion of attorney-client privilege by Donald Trump. Now, look, having said all that, there's been a lot of speculation about what happens over the next month or beyond next month, because Chief Judge Beryl Howell is stepping down as chief judge, and that position is going to rotate as it does in the D.C. circuit by seniority to the next most senior judge. So look, the Department of Justice for the last 2 years has had a good ride with Beryl Howell. She's sided with them almost every time when it mattered against Donald Trump. She's even the one that is in charge ultimately of the subpoena and the search warrant related to Mar-a-Lago. But I think there's been a lot of hand-wringing about, well, we're going to lose the judge that we love a lot. Well, firstly, I think that's going to make Jack Smith and his team move even faster and with more velocity than they are right now to take advantage of having a judge who is, sort of siding with them time and time again. So they're trying right now to really do the hard math, do the hard calculus with this teacher they love, with this judge that they are getting great rulings from. So it's going to be a very busy month. It would have been a very busy month anyway as we round out of February into March, because, Jack Smith's been on the job since November. And it's hard to believe it's been about less than 6 months, but that's what it's been. So he's wrapping up Mar-a-Lago, wants to do that, certainly before we find another group of classified documents somewhere else other than in Trump's house, maybe held by somebody else. So he's moving really fast, and he's going to lose Beryl Howell. Now, who comes in next? Let's just put that on our homework assignment here, so we could all look at it. And this is the next one up in the chief judge world. It's going to be Judge Jeb Boasby. Judge Jeb Boasby, a 2011 Obama appointee, a Yale Law 1990 grad, formerly worked in California, which is a pretty liberal district, clerked in California as well, was an assistant U.S. attorney in the D.C. circuit, and did a lot of homicide prosecutions in that role. Now, he's been on the U.S. Foreign Intelligence Surveillance Court. He presided over it for a number of years. He's a real judge, Democrat leaning. So we shouldn't worry that there's a Trumper that's now taking over the decisions about Trump. It's the right party, if you get my drift about the judge. Now, when you dig a little deeper, he's had a couple of rulings that might give people some pause. I'm sure we're all tired of hearing about Hillary Clinton's email server. I know the Hunter Biden laptop has sort of replaced it, or now the Donald Trump laptop containing classified documents that were handed over to an aide that works at his Save America PAC. But if you go back to the original, technological device scandal, it was the Clinton email server. And after it was all done, one of these right-wing organizations claiming First Amendment right and a FOIA, a Freedom of Information Act request, wanted all of the work emails, if you will, of Hillary Clinton, not her personal ones, but her work emails, which frankly, if they're not classified and not redacted, people can ask to see them. And this judge did rule that 14,000 pages of not classified, not personal emails of Hillary Clinton while she was Secretary of State needed to be turned over to the public. It was much ado about nothing. Not much came out of it. Not much was written about it. It wasn't certainly like WikiLeaks or the Twitter files or anything like that. But look, I assumed, I wasn't involved with the case, but I assumed he analyzed the briefing and the issues and made what he thought was a proper decision. And it seems to have been upheld through the appellate courts. So that's where we are. But there's no reason to believe that this Obama appointee is going to veer off tremendously. knowing that there's already a body of law from that court and a very well-respected judge in Beryl Howell, who's not going anywhere. She's not retiring. She's just stepping down as the chief judge. And so I think he would be loath to, really jump the rails and make decisions that were not in keeping with the body of jurisprudence already developed by Beryl Howell. His clerks will all have access to it, of course. They will review all of it, and I'm sure he's gonna stay in the lanes drawn for him by Beryl Howell. So I think it's especially on this side of the aisle, we like to do a lot of hand wringing. Oh my God, we're losing Beryl Howell. I mean, I remember 2 months ago, she made one decision about trying to find Trump in contempt or not, and the whole world was like anti-Beryl Howell. Let's just keep cooler heads here. Beryl Howell was very good because the law in the area is very good, and the facts are against Donald Trump. And so a prudent, sober judge like Beryl Howell ruled time and time again for the Department of Justice to tear down the attorney-client privilege and force lawyers for Donald Trump to testify at the Department of Justice. I have no reason sitting here now to believe that Jeb Boasby, the soon-to-be chief judge of the D.C. Circuit Court, a Democrat-appointed, Obama-appointed guy who clerked in California for a very liberal judge, is going to suddenly, break the chain and not follow Beryl Howell's teachings. I don't think that's going to happen. We'll follow it closely. Now, if you like these kind of hot takes, I do them about once a day. I co-anchor the leading podcast at the intersection of law and politics. It's called Legal AF. It's on the Meidas Media Network, but you know that already because you're here. And you can also follow me on social media at MS Popok. This is Michael Popok reporting for Legal AF.
The best part of waking up? MAGA tears in my cup. Check out the new MAGA tears mug available now at store.MeidasTouch.com. That's store.MeidasTouch.com. It's 100% union made right here in the USA. I know I'm not tired of winning yet. How about you? Get yours today.